Thank you for joining us, and thank you to our individual donors who make it possible to offer these free educational events. The purpose of these events is to raise awareness and facilitate discussion about important issues related to access and medical assistance in dying, otherwise known as MAiD. MAiDHouse values inclusion, diversity, equity, and access. Please note the diversity statement in the chat. I would like to take a moment for the land acknowledgement. In addition to the land acknowledgement, we take the time to remember all of the lives impacted by the residential school system and join the call for a government-funded nationwide search for unmarked graves at residential school, and that we all start supporting the Truth and Reconciliation Commission of Canada calls to action. We acknowledge as a virtual event, we span many traditional territories. For the host of this meeting, there are traditional territory of many nations, including the Mississauga of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people, and now home to many diverse First Nations and Métis people. We also acknowledge that Toronto is covered by Treaty 13 with the Mississauga of Credit. It is my pleasure to introduce Senator Pamela Wallin, our first speaker. The Honorable Pamela Wallen has been a journalist, an entrepreneur, a corporate director, and an author. In the wake of 9/11, she was appointed Consular General of Canada in New York and was subsequently appointed to the Senate of Canada in 2009, where she still serves as an independent senator for Saskatchewan. Ms. Wallen is an officer of the Order of Canada, Canada's highest civilian honor, and a member of the Saskatchewan Order of Merit, and a former chancellor of the University of Guelph. She has 14 honorary doctorates, and among many other honors, she has been named to the Canadian Broadcasting Hall of Fame. Pamela has on 4 occasions been recognized by Queen Elizabeth II for her public service and achievements. She is author of 3 best-selling books and now also hosts the podcast, No Nonsense with Pamela Wallen. Today, Pamela joins us to discuss her commitment to Advance Directives as a way to enhance access to MAiD in Canada. She will also answer pressing questions on the current debate at the Special Joint Committee on Medical Assistance in Dying. Pamela, thank you for joining us.
Thanks, Tekla, very much, and to everybody at MAiDHouse for taking this issue on. I'm also honored, I will say tonight, and you'll see it in a few minutes, to be sharing the screen with my friend Ron Posno, his wife Sandy, who is an advocate for this extraordinaire, and Dr. Ellen Wiebe, who is one of the country's leading experts in the field. So I'm really looking forward to this. I am here tonight because of my mother, because of my grandmother, and because of me. I come to this whole debate from deep personal experience, and I'm grateful to have a platform in the Senate to try and change the laws on things like advance directives to affect an issue that is so profoundly impacting us and our families and what we are experiencing as a nation. I'm just going to borrow some recent stats from a piece in Maclean's magazine. In 2011, boomers began turning 65 at the rate of 1,000 a day. So if you skip 10 years forward now, in 2031, there will be 1,000 boomers a day turning 85. If you do the math, that means a quarter of the population will be seniors. Increasingly, this group is struck by the fear of living with the death of dementia, or as others have called it, the end of memory. This is a human dilemma impacting some 600,000 Canadians and their families and communities today. And the fiscal picture is a little frightening too, because unpaid dementia care is about $60 billion a year in North America. This is income that is foregone and forfeited by those who must give care and by the families who are looking after someone who's impacted. Paid care costs are about $250 billion a year in the US, so about $25 billion a year here. Increases in life expectancy have been accompanied by more and more years of age-induced disability. Modern medicine has given us a longer life, but also made us the victim in some senses of overtreatment. We must strive to seek rational death where possible and to prevent deaths of despair. An advanced request is an agreement to seek medical assistance in dying, even though your death is not imminent, or in the event that you may lose the capacity to consent in the final moments. Unfortunately, since the passage of Bill C-14 4 years ago and Bill C-7 this spring, and the rejection of many Senate amendments, we still witness people with intolerable suffering being driven to the end of their lives earlier than they want. We have heard the sad stories of rural Canadians unable to receive proper or timely MAiD assessment or administration. And we have seen seniors continue to live out the last years of their life suffering from the profound pain of not knowing who they once were. This is cruel, and it is a burden upon those whom we owe the most. Our mothers, our fathers, our loved ones, our elders, our husbands, our wives, and those, of course, who fought for all of our rights. The rules are unfair and fall short of what the Supreme Court of Canada itself said was constitutional and fair. There is the obvious catch-22 for those with dementia, and this is the case where the need is the greatest. We want to be able to spell out in advance the circumstances of when our life would be intolerable to us, a decision we make of sound mind, and that could be carried out despite our inability to knowingly consent or even remember that we, in an earlier life, had consented. It is true that there has been some progress because of the changes brought about by C7. There are now some very specific cases where an advance request for MAiD will indeed be honored, but you have to have been already approved for MAiD, and your death needs to be reasonably foreseeable in most cases. This does not mean that a written agreement to have MAiD performed before losing capacity will be honored either. It hasn't really fixed the problem. People suffering from forms of dementia like Alzheimer's can't undergo MAiD because their deaths are not reasonably foreseeable and they no longer have that capacity to give final consent. It's called the illness lottery, the catch-22. You can't ask before you're diagnosed, and once you're diagnosed, you can't ask. And those were the circumstances for several members of my family. I introduced an amendment this spring to Bill C-7 to respect the needs of this group in particular. The amendment passed the Senate, but was struck down by the Government of Canada. So progress is stalled a bit, but we are now taking slow steps forward. A committee, a joint committee of the House and the Senate to look at advance requests, among other topics related to MAiD, was struck last month. And we had our first witnesses yesterday, but it will be slow going. And of course, if there's an election, sadly, the committee and this whole process will die. As a society, we do already accept DNRs, do not resuscitate orders, and living wills, and advance requests are just part of that continuum. You may sign a DNR if you're undergoing life-threatening surgery or want to state your wishes so that in case of an accident, you don't want to have any extraordinary measures employed just to keep you alive in a vegetative state. Why would we not offer the same choice to those trapped in a world where they do not know themselves or who they once were? The government's own public consultation on MAiD from March of last year found that almost 80% of Canadians support advanced requests for MAiD, even more in the particular cases of dementia or Alzheimer's. I believe that our current medical assistance in dying laws should reflect the will of Canadians and their clear and growing desire to have the right to choose a dignified and respectable death. 1 in 4 Canadians over the age of 85 suffers from dementia, and their death may not be reasonably foreseeable. These numbers alone, the so-called silver tsunami, reinforces the reality that the demand for advance requests will only grow. Consenting in advance to medical assistance in dying is not a privilege. It should be our right. So the time is now to be brave and to offer those who have done so much for each of us, our parents and grandparents and husbands and wives and our seniors and our elders, to say thank you for all that you have done for us and for our country and for our communities, and then to give them, if they so choose, the right to leave us with dignity, just as they have lived and loved and served us all with dignity. Thanks very much.
Whoops. Thank you, Senator Wallin, for those words and the concept of thinking about what a rational death is or versus a death of despair, and the intersection between the strong public support around advanced requests and looking at how we can have those conversations and move this work forward. As Pamela mentioned, this impacts real people, our mothers, our fathers, our community, and particularly people who are genetically predisposed to dementia or have been diagnosed with dementia and are considering MAiD and are directly impacted by the committee's decision. I now have the pleasure to introduce Dr. Ron Posino. Ron is 81 years of age and has dementia, formally assessed with a minor cognitive impairment in 2016. Born and raised and living in London, Ontario, Ron has also resided in Quebec, Germany, and Calgary. He received his formal schooling from Collège Militaire Royal, University of Western Ontario, Wayne State University, and the University of Toronto. Nationally recognized for curriculum innovation in special education, Ron was a teacher consultant and a school superintendent. As a tireless advocate for people with exceptional needs, Ron has lectured in 13 universities and colleges in Canada and the United States. Before retirement, he became a popular motivational speaker, addressing change in business and public institutions. Now he speaks for people with dementia and their caregivers. Dr. Ron Posno? You can turn on your camera. There we go.
There we are.
Excellent.
I forgot I had to do that.
Yes, thank you, Ron, for joining us.
I'm glad to be here, and thank you very much for the introduction, and particularly for MAiDHouse for sponsoring this particular event. I share very much the feelings and concerns that Senator Pamela Wallin has addressed. But I'm going to address this from a very personal perspective, the people perspective, me particularly. I'm an example here. And I'm going to share with you my perspective in getting here. Back in 2016, I was assessed, as you noticed. And with assessment, I started looking up everything I could find about dementia and MAiD. Now, MAiD had just been introduced in the legislature in June 2016. And I was struck by the fact that they did not consult with the users and doers. Dr. Ellen Wiebe is a doer. She has to do the job. I'm going to be a user. But nobody asked us. They asked the Canadian College of Academies. They did a subsequent contract with the same college to provide problems associated with MAiD, not solutions, only problems. And the Canadian College did a great job. They produced over 200 pages, 244, I think, of problems. Well, we don't need problems. We need solutions. I know people, I'm not, thank God, I'm not. But for a past number of years, I have substituted or volunteered with the Dying with Dignity group because one of the problems we had was that every applicant, every person requesting MAiD had to have 2 independent witnesses. 2 independent witnesses. For what? The Canadian College of Academics calls these protections and safeguards. My question is, who are we protecting? Because I haven't seen any evidence of protecting a patient. I see questions about protecting the doers, the physicians, the people who have to do the job, and the protections, particularly of our lawmakers. But it's provided excuses and roadblocks and heartaches and tears, and people are dying in agony because of these safeguards and protections. So I'm very much saying that MAiD has to be revised. We can't go back to the first basis, but I'll just point out where we started with this thing. Suicide was made legal in 1972 with the Sue Rodriguez case, and then particularly with the Kay Carter case in 2015. This issue of can we help somebody commit suicide came to fore. There was no provision to allow somebody, if a husband or a wife tried to help their spouse who was suffering by giving them medication, that person may die, yeah, thank goodness, but the person providing help would be punished under law. So in 2015, the Supreme Court of Canada, in acknowledging that suicide was legal, also made it possible and directed the legislature of Canada to change the law, make it possible for physicians to provide assistance in dying. That's what the Supreme Court said. That's, to me, is straightforward and simple, and we end up with MAiD, which is pages and pages and pages of safeguards and protections. We need to keep it simple. Remember that old thing, the KISS principle? Well, I modified it a little bit just because we want to keep things polite. I call it keep it simple and smart. We're in a position to do that. And as Senator Pamela Wallin's worked out, I would hope this review committee would keep it simple and smart and talk to some of the users and doers about the problems that exist with MAiD today. Now, I've got a lot more to say, and I'll likely have to go. I'm going to pass.
Thank you, Ron, for those words and sharing your perspective. And as you mentioned, there's the intersection between the legislation, people who this legislation impacts, and then those who provide MAiD, the MAiD providers and assessors. I'm pleased to introduce Dr. Ellen Wiebe. Dr. Ellen Wiebe is a clinical professor in the Department of Family Practice at the University of British Columbia. After 30 years of full service family practice, she now restricts her practice to women's health and assisted death. She is the medical director of Willow Clinic in Vancouver and provides medical abortions and contraceptions. She is a board member of the research director of the Canadian Association of MAiD Assessors and Providers, CAMAP. She chaired the working group for the CAMAP guidelines on MAiD and dementia, assessing capacity for MAiD, and MAiD assessments for people with complex chronic conditions and somatic symptom and related disorders. Ellen, thank you for joining us this evening.
So glad to be here. Okay. Let me get my slides up. All right, so I'm going to talk to you about what it's like to actually provide and what it means when it comes to dementia and advance requests. So my experience over the last 5 years has been this. I have provided for people with 300 plus people with medical assistance in dying. And you can see that, like everywhere else, most of them have malignancy, but some of them had dementia. Assessed more of them, and the ones that I refused, generally I was refusing because they either did not have the capacity to make decisions or their natural death was not reasonably foreseeable. And that, of course, was before the law changed. So if I look just at the dementia patients that I have provided for or assessed, you can see that most of them had Alzheimer's, which is the most common form of dementia in Canada, in the world. And then there were some other forms. The bottom one is Creutzfeldt-Jakob disease or mad-cow disease. And so what and how do I provide for my dementia patients? Now, first of all, it usually involves repeated visits to talk about the progress of the disease, make sure that, in fact, they do have capacity. I collaborate with other physicians, and we search for the 10 minutes to midnight. This is the time when they are about to lose capacity, and therefore at the stage, what I say to my patients when I first meet them is that if they want me to, I will work with them to find the time when I say to them, it's now or never. If you want to have MAiD, you'll have to do it now because you'll lose your ability to do that. And so, of course, these people have chosen to die sooner than they would like because there still are, lots of aspects of their life that they're enjoying. But they do it because they won't take the risk of more deterioration from their disease. Now, you've got a problem when you're thinking about what Ron and Pamela were just saying, that they want the law changed. You can change the law, and if you haven't got providers that are willing to provide, nobody has the right. So we did a study where we were looking at the gap between the public's desire to include specific circumstances and then providers' willingness to provide MAiD. So with the orange bars are the public's desire in different situations. Dignity, the question had to do with, being diapered, being incontinent. Freedom as to whether they needed to be put onto a locked ward, whether they family means, did they recognize family, memory, completely lost any short-term memory, and behavior, that their behavior was such that they needed restraints, chemical or physical, because they were becoming violent. So if you look at when a provider was willing to provide, you look at the 4 shades of gray. So with the patient's consent, no problem. That's the darkest gray. Most providers are willing to provide, no problem. With advance request alone, just the written statement, you can see that we're down at 31%, 32%, 34%, 19%. So there are providers who are willing to provide, but not very many. And I also think that the providers that were in this study were the most experienced and perhaps most liberal of the MAiD assessors and providers. So now I want to talk about our current law and what difference that is. Now we have something called the Waiver of Final Consent. Since March, I have signed many of these. This is an agreement between the provider and the patient. The patient must be eligible for MAiD. That does not mean they have a natural death that's reasonably foreseeable, because our law now doesn't require that. So they need to have a grievous and irremediable condition. They need to be in an advanced state of declining capacity. They need to be suffering unbearably. And so many people with the early diagnosis of Alzheimer's fit that. They may not be in an advanced state of capacity if you're looking at all Alzheimer's people, but in terms of what they could used to do and what they can do now, they are in an advanced state. So there are people, and you saw that I have provided for these, who did qualify under being in an advanced state of declining capacity and in a grievous and irremediable condition. They must have a date set for MAiD, but there's no restrictions on this date. It could be 10 years out if you actually could find a provider who's willing to. And I'm not one of those. Besides which, I'm 69 years old. So if you signed an agreement with me, you have to make sure I was still working at the age of 79. And there are maybe some doubts about that. Now, you also have to realize that if you sign a waiver of final consent and you're saying that the MAiD provider may provide even though you aren't able to give consent, you can't ask for it. So you have to have somebody who will trigger that request. So you have to have an agreement with someone else as well that would say now he needs MAiD because he said he did, and this is what he wanted, and I have the document that he doesn't need to consent. And in addition, the law says that the patient did not, by words, sounds, or gestures, demonstrate refusal or resistance to having the substance administered. So I can tell you that I am really uncomfortable about the idea that I'm going to ever provide for somebody who is not currently capable. I wouldn't have any trouble if it was someone like the person that I'm going to be providing for tonight, who is very, very, very ill. And if he slipped into a coma before I get to his home tonight, and he had signed a waiver of consent, which he has not, I would be happy to go ahead because I just talked to him today. Now, when it comes to somebody that I talked to a year ago, or even maybe 3 months ago, I'm going to have more difficulty. But I have signed waivers for 3 months. I've signed waivers for 6 months, but no longer than that. And it's hard. It's hard. It's hard to go through the discussion with patients, and it's hard as a provider to think about doing these.
Thank you, Ellen, for those thoughtful words, and also drawing in where we're beginning to see the intersection between the legislation, those who are eligible for MAiD or thinking about MAiD, and then those who provide MAiD, the MAiD providers and assessors. Senator Pamela and Ron, if you could join us.
Great.
We're going to now move forward with the panelists to speak together and answer your questions. You will see that there's a Q&A function. If you could put your questions in the Q&A function, and I will help provide those to the panelists. And I think it's really interesting. We had Pamela open the discussion with that concept of rational death and, versus a death despair. And then Ron talked about, his choice and his autonomy about what that would look like. And then we talked to Ellen, who brings in, the different ways that it's working now, how that the disparity or differentiation between what people want and what MAiD providers are to do, and how you meet that intersection. So for the panelists, for the first question, can we just explore a little bit, about what we have now and how we're proposed moving forward, and to elaborate a little bit more of the challenges and the solutions that you see with, what's being discussed so far?
I'll kick in a bit here, if it's all right, a bit.
That's great, Ron.
I don't need to explain this for Pam or Dr. Wiebe, but there are a number of people in the audience who haven't had enough shared experience. In fact, the word dementia means all kinds of things. And when we're going to talk about waiver of final consent and what Ellen was talking about being 3 months or 6 months, you better understand this. There's some basic aspects of dementia. I have dementia. I was assessed almost 6 years ago. I'm on a very slow decline. Now, it's not curable. We can't fix it. I'm on a decline. Everybody with dementia, and there are at least 13 different kinds of dementia, has a different rate of decline. Some can decline terribly so in less than 3 years. From life to death in less than 3 years. Others, it's going to be 10 years plus. My case, it's going to be slow. Thank goodness. I have no problem with that. I'm pleased with that. But you must understand that it's irreversible. And when we're talking about when do you consent, here I am, still reasonably cogent and rational. I could provide you with a consent. But if you're going to do that and kill me off in 3 months, that's a way too soon. I don't expect to have just 3 more months of life, or even 3 years. It's going to be longer than that. So I want you to understand this, that what I want an advance directive for is that, hey, I understand I'm going to die, but I don't want to die from dementia. I want to die when I lose control of my life. And there's a difference, and I use these 2 words. Living is where you can still think and interact and react to the world in which you happen to exist. But it'll be reach a point in my decline where my functionability is down to that of a child and lessening. I'm no longer rational. I'm no longer interacting with the world. I can't possibly sign a waiver of final consent. I can't possibly agree to do it. So I want to be able to do that all in advance and let that decline. My substitute decision maker or my personal attorney for health can say, hey, this is the time that Ron wanted to go.
Lots of people have done what Ron is suggesting, because there is that point, particularly with all the various forms of dementia, where you may have of sound mind and body much earlier on laid out the conditions and been very specific about it. When I can no longer care for myself, when I am incontinent, when I cannot feed myself, whatever the cases may be. But by the time it comes for that final consent, you are not able to do that. You are living in another world where your reality is not that. It is not a reflection of who you are. You have become somebody that's been captured by this illness. And so if asked, you may say, no, I don't know what you're talking about. I want to dance. I want to listen to music. And we in the outside world say, look, isn't that person happy? But that is not what they asked for or what they wanted when they were of sound mind. And we have to bridge that gap.
Yes, think about it. There is a person like me who has to then end that person's life. I won't end the life of a person who looks perfectly happy because they wrote something when they were a different person. I won't. And there's a whole lot of other people like me, which you just saw from the results of the study.
That's the dilemma, for sure.
You are not going to get somebody to do this. When we end the lives of our pets, we do it without consent, but we do it at a time when we think that they are suffering. And we find that that's possible. So it is possible that if I saw somebody who appeared to be suffering and there was that written statement and that I might be capable of it, it is it's a huge responsibility to end the life of another person. And I do it a lot. I'm going to do it again today. But it's not straightforward.
And I think that kind of segues into the next question that we have from the audience, because again, it's that intersection when we're talking about autonomy and who has the right, and you have these different people. I'm making a decision for my life. Ron's talking about his life, but also talking about the MAiD providers and assessors who have to do that, and where that intersection. So the question is, what would be the biggest issue? And it seems like we're touching on it if advance directives became possible, and what would need to be in place prior? Like, what would that look like for MAiD teams? And what could we do to, lower that discomfort and still allow people the rationale of death and the concept of the good death? Ron, do you have some thoughts about that?
Oh, absolutely. Yes, and I can understand and appreciate Ellen's point of view, and I've talked this over with some other physicians and their concerns about this. But to me, this boils down to the difference between life and living and existing. In my specific case, as Pamela has already suggested, some years ago, I laid out 8 very specific conditions, which in my road of decline are like signposts. They're not necessarily all going to appear, but when one appears on my rate of decline, I'm just going to continue decline. I don't want to go past that point. And appearances don't mean a damn. I have met and know people with dementia that outside, they are all right. You feed them, you touch their lips with a spoon and put the pablum in. Now it has to be pablum because they don't know how to chew anymore. It reaches a point in their decline when they can't even swallow. I don't want to get there. There's a lady I know very well, a very well-trained, highly health professional. She wanted to have, this is before we had MAiD, but she wanted to go, but she couldn't. The law didn't permit it. And there she is sitting there now with her care provider trying to feed her pablum on a spoon, and you just watch her. It's like feeding a bird. Touch the lips, mouth opens, dump it in, close it up again. So I could be happy. I could be happy. I appear to be happy. Your body is reacting. You give me a hug, you give me a teddy bear, and I may smile. I may go to bed with my teddy bear and smile. But on the other hand, I may smack you in the nose when you hand me the teddy bear. My mind is gone. I don't want to live like that.
Those of us who've gone through this with loved ones, people that we know intimately, like Sandy and Ron, and I certainly went through this with my mother. She was a very dignified woman, always dressed to the nines. She was a teacher. She never went out anywhere without her hair done, her makeup on, her shoes that matched. That is how she saw herself and felt that she should present herself in a community where she was a teacher. But it mattered to her. Even in retirement, she was the same. And even when she went to the old folks home, to the seniors residence, she was the same. And as she, as Ron describes, eventually lost each one of those things day by day, month by month, and lost all ability to even comprehend those things that mattered to her, her life from her point of view, and I know this because we'd had these discussions prior. This is the kind of conversation that went on at our supper table. We talked very frankly and bluntly about these questions about funerals and dying and signing DNRs and all of those things. So it was an honest way. She, I know, and my father and her husband knew, and my sister knew, that this is not a life in any way that she would have chosen, and she would have preferred to go, but there's the catch-22. You can't ask in advance, and once you've been diagnosed or gone so far into the illness, as Ron describes, where there's 1 or 2 or 5 or 7 of the 8 symptoms, you're beyond being able to consent in any real way. We've got to be able to take the word of people like Ron and people like my mother, who would have put this down on paper and said, these are the circumstances. And regardless of my emotions at the time, the hugging of the teddy bear or the punching you for the teddy bear, this is what I wanted, and that's why I did it in advance. I know it's not easy, and I know lots of, Ellen's life is not easy, and that's why there are so few that want to engage in this. But because it's difficult, we can't walk away from it. We need to confront it.
So Ellen, lots of people are asking and noting in the questions and in the chat, the thank you for what you do and the acknowledgement of your skill and expertise, and are wondering what would need to change in the legislation or in practice that would make you, as an example, or other MAiD providers more comfortable. There was the suggestion about possibly, being able to make a videotape and where you could see the consent and the process. Would that help? Or as Pamela talked about, lots of family discussions. So you have a circle of care that have witnessed and acknowledged this and can be like the conveyors of those conversations. So just in generally, where you think might what help in practice to increase comfort, and if you could speak a little bit to that.
Yes, I can. So I had a patient with Alzheimer's who was competent and it deteriorating fairly quickly. And we went through the process with his other physicians that we would check in with him every 2 weeks because of his decline. And we got to the point where I said to him, this is it. You now don't have another month. If you want to have MAiD, you're going to have to give up. And it was at the beginning of the summer, and he said that, he was looking forward to the summer. And I told him that he wasn't going to be able to if he wanted to have MAiD. He had a video, just like what you said. He was an activist, a little bit like Ron, and he had made a video, and he was so articulate in the video about not wanting to lose his independence, not wanting to lose his abilities. And when I saw him the next time, because he didn't want to set his date the day that I said that, I saw him the next time. I said, "How are you doing?" And he said, "I'm getting better." And I said, "Oh, okay. Well, I read the neurology report from your last exam. And I think that you are actually deteriorating. You realize that your condition will lead you to need a care home soon. Is that okay with you?" And he said, "Yeah, I want to keep living." And so he did not get MAiD. And I've had others who did that. And there is no way with a waiver of consent that I would provide for such a person. He was happy. He had originally said that if he lost his ability to take care of himself, he could not go on. But when he actually lost the ability to take care of himself, he was, care home, whatever.
Ron, you have some thoughts?
Oh, I do. I've thought about it a fair amount. And preparing and signing an advance request does not mean that it's an absolute. I can withdraw that request at any time, up until the time the provider gives me the needle. I understand that. But you see, for everyone that's going to say no at the last minute, under circumstances as you as practitioner would say yes, they're entitled to say no, there are at least 8 or 9 others who are not going to say no, who won't say no, they're going to take it. And
But
they're
we're
going
talking
to
about
they're going to be
people-
very happy to do that. So all
Ron-
I want is an advance request
Yeah.
with,
Ron,
with the
we are talking
conditions laid
about
out.
people who are competent. So I have no trouble with the ones who are still competent and able to ask for MAiD. No problem.
But that's the issue here, because it's the definition of competent. Of course, the person was still living in their own home, the one that you refer to, and had changed his mind, I believe, because he was no longer aware of the circumstances. He thought he
No
was getting.
longer understood Alzheimer's at
Correct.
all.
So that's precisely the dilemma with dementia and Alzheimer's, which is why so many of us want to be able to make that request in advance. My mother would have done the same thing if you'd walked into her room on any number of days and said, so you remember that you asked for MAiD and today's the day. She would say, I don't need a MAiD. My room is clean. You know, like, you have to be able to have that discussion and respect the discussion and the wishes that they uttered at a time when they were in control of their faculties. And I think that's what we're trying to wrestle with, because that final ask that you have to make, obviously, and quite rightly, and even for legal and constitutional grounds, there has to be a way for the person who is making the ask to have that ask respected when they were of sound mind and protected as well. So that's where the rubber hits the road, and that's what we have to try and resolve.
And this is on a slightly different topic. So there's a lot of in the chats and questions about people creatively brainstorming what would be in place so that you would follow. If I'm more descriptive, would that help? How do I get my substitute decision maker to make sure they follow through and that actually holds weight in terms of the decision? But another part of the conversation people are bringing in, which I think is quite interesting, because we know in the larger review of MAiD that this is a issue that has been raised, is that concept of equity and what is access. So people are supportive of Advance Directives, but they want to know if that is actually going to enhance or increase the gap between those who have the capacity to create one and those who don't. So while they support Advance Directives, they do wonder or question what that does to the equity agenda in terms of access to MAiD. Who will know how to work the system? How will they access that? How do you find a MAiD provider or assessor who will work with you on that? So Pamela, let's start with you there in terms of what you're thinking.
Well, those are serious issues, and I literally have, over the course of the last 7 or 8 years, talked to hundreds of people who are wrestling with this issue, either directly or for a family member. And some of the realities of life in Canada come into play. It's much more difficult in rural areas. In many rural areas, you're lucky if there is one doctor, never mind a doctor that may agree to assess you for MAiD or even recommend you to someone. It may mean a 2 or 3 hour trip to the city on repeated basis. The one upside, if I can say, of the pandemic is that a lot of people have learned to meet the way we are meeting now. And some of the MAiD assessors have agreed to take that as you know, a legitimate exchange. They always like to be there in person so that they can know that there's no influence being exerted. So there's issues of just the rural-urban divide and accessibility. And I think there are, you know, if you live in a city and if you're wealthy and if you have access to good medical care and many choices on medical care, you can find somebody who will help you in that situation. If you're working, you know, 12 hours a day and you have 3 kids at home and, you know, no support, it's hard to take an afternoon off to go and talk to medical professionals or to go through this process. I think there's a lot on both sides of the fence, both for the Rons and of the world and the Pamelas of the world and the Ellens of the world, because Ellen needs to be assured that she's doing the right thing in the right circumstance. So there are definitely accessibility questions that we also have to wrestle with.
Ellen, Ron, anything to add to that question about the equity and advance directives, and then if that enhances the gap that people are worried about?
Well, I don't know if we can ever make things equal for every Canadian,
Right.
wherever they happen to live. But I do believe this, and I know this, and Helen is a perfect example. There are health professionals out there who provide health services. And there are health professionals out there who provide health care. The health service person is the person that goes in with the checklist and checks off the boxes of things that the bureaucrats require. The physicians, the nurse providers, the nurses who care about the person's health will go in and talk about it and reach an empathetic kind of resolution to their issues. I knew Dr. Wiebe some years ago by reputation, not personally, because he's out in British Columbia and I'm stuck here in London, Ontario. But she was a leader. She was one of these rare, too rare, health professionals who cared, who provides health care. And I would have no problem if Ellen would be prepared to sit and work with me as we sort out an advance directive and the concerns that she has, where we're at, because she cares about where I'm at and how we're going to get this thing resolved. So what I'm getting at is that the person who's requesting has to do some research, has to do some finding, and has to find a health professional who is going to provide health care.
Ellen, any thoughts?
So I can tell you that with the new law that came into place in March, we now have even more problems with equity in the sense that there's many providers who are not comfortable with people who approving anybody whose natural death is not reasonably foreseeable. And that means that, you know, again, the law changed, but the provider situation changed only partially. So this is what I'm saying about advance directives. If we got to the point where a written statement and a substitute decision maker was all I had, because I've never been able to really communicate with this person ever, I only meet them at the end. Would I be able to do it? I don't know. We don't have a law that allows me to, but you're talking about putting in a law that would be exactly that, that I would arrive, meet a person who I couldn't communicate with, and they had a written directive and a substitute decision maker who asked me for MAiD. Is it possible? Yeah, it's possible. I would certainly feel a need to see some suffering.
Ellen, can I ask you a question on that? What is your response to the using Zoom, using technology? I mean, if you're in BC, and so that qualifies as far as you're concerned for giving you peace of mind or the ability to make a judgment call that you think you need.
Oh, absolutely. Oh, yes. No, I do lots of my assessments on Zoom.
Okay.
Does that mean your original assessment, or does that mean, because I'm thinking particularly of the geriatrician who did my assessment for dementia. And she's a wonderful person, and we have a good professional working relationship. But when I was doing my follow-up a year ago, we got through it, and she says, basically, let's just suspend this until you need me. If you need me, let me get back to you. Because she couldn't do the assessment by phone. I could answer all the questions, But it takes more than that. Ellen, you know so well. It takes that kind of trusting personal relationship to evolve the kind of understanding you're talking about.
No, for some patients who are requesting MAiD, their ability to communicate is very limited. You know, I mean, my ALS patients, many of them can't talk at all. So we are communicating in a different kind of way. And many of my patients, like the one that I'm providing for tonight, is very, very ill, too ill for any kind of conversation. He can talk, but a few words, and that's all he can do. So no, I mean, I can do assessments in people who can't talk. When it comes to doing an assessment in somebody with dementia, some of them, you know, can't communicate very well, but I can still do assessments. So no, it's individual. It's absolutely individual. There's very specific things that we look for capacity. They need to understand their condition. They need to understand their prognosis. They need to understand their alternatives, MAiD and whatever else, going into a care home, for example. And they need to be able to communicate that choice and be able to reason that decision. And I can get that. I can understand that somebody is capable of that, even if they are using yeses and nos only.
That's a little bit of what we call well, certainly the catch-22, but the diagnosis lottery, that if you are dying of a severe illness, a cancer, and it's at an advanced stage, and you, Ellen, know that the person is suffering because you know what the level of pain is at stage 4 cancer of the brain, whatever it may be, you don't need to have that ultimate yes or no at the end because you've already had that discussion. As you say, you talk to your client, your patient today. So if you get there and that person, there's too much morphine on board or whatever, can't really respond, you still know. This is exactly the catch-22 for dementia, Alzheimer's, all of these things, because the person may be perfectly coherent, as in able to say, yes, no, let's dance, it's Tuesday, but not aware of their own condition and therefore not allowed to give that consent. So that's what this whole discussion about advance directives really comes down to. It's kind of clear if you have one of those diseases where the medical profession all agrees that you're in pain and it's irremediable and it's suffering, and people have this notion that as long as you're in the seniors residence and tapping your foot to the music and or lying in your bed and allowing your loved one to, as Ron described, you know, feed you a bit of pablum, that is somehow living. And I think what we're trying to wrestle with here is that that's not a life that many people want to choose, which is exactly why they want to come to this case of an advance directive, so that they don't get to that stage, nor are they left in that stage.
So I think as we're coming near the end, that this conversation has really highlighted that, you know, there is the will of the people believe in the advance directives, and there is the need for legislation. And then further on to that, it's figuring out the logistics of what that means and that ongoing conversation. Because if you look at the conversations and chats, people have tons of stories of their loved ones watching and witnessing and saying, why didn't we give them the autonomy? They were very clear. We're hearing of MAiD providers saying, I would, and Ellen's talked about different creative ways she has to work and, you know, work with persons on the autonomy. And it seems like we need to continue those conversations in the concept of being allowed to do advance directives. And what will be an advance directive for me will not be the same as what it is for Ron, will not be the same for what it is for Pamela, and will not be the same for how Ellen wants to interact with that and what that looks like as a MAiD provider. So I think also the importance of supporting the MAiD providers and assessors as they tackle this, you know, practice versus whether it should be law or not, I think is, you know, kind of a theme that's come through. And, you know, some of the questions are about, you know, someone gives a sign at this time, but, you know, maybe in a year or two, they give another sign. And so there has to be this ongoing relationship as well. And and how that would change. So as these events are meant to do, you guys have generated a lot of thought and food for thought, some of the challenges, some of the advancement, and definitely echoing what people are putting in the questions. We weren't able to get to all the questions, but we will definitely be writing some responses after, some Q&As. So I'd like to take this moment to thank Pamela, Ellen, Ron, for your time, your expertise, and really being willing to share and be the point to generate this discussion with your thoughtful presentations. I thank all those who have joined us tonight, who are clearly engaged with the issue and this critical discussion as it relates to access and MAiD, and that it's really important that we carry on these ongoing discussions and hope that we do get the legislation that allows us to work out the nuts and bolts of what needs to happen. To ensure that our events are as informative and meaningful as possible, please fill out the poll that is going to be put in the chat or will be in the chat now. That helps us decide where to go next. Our next virtual event, Successfully Navigating MAiD, What Should You Know, with Dr. Susan Woolhouse, is being co-hosted with Dying Dignity Canada Toronto chapter and will be on September 28th at 7 p.m. So stay tuned for registration. MAiDHouse works to ensure a community where everyone has access to a place for MAiD. So again, we thank our individual donors who make our work possible, that of providing access for a place to MAiD, as well as these educational events. We do encourage you to explore our website, our resources, and if possible, to make a small donation to support future educational events. Again, thank you so much for our panelists, and I'm wishing everyone a lovely evening. Thanks so much for joining us, and do please take a moment to answer the poll, which I see is happening right now. Thank you.
Thanks very much. Bye, Ellen. Bye, Ron.
Goodbye.